Hello, everyone, and thank you for joining us today for our summer webinar series. Today, we are going to dive into updates about Minnesota employment laws and paid leave requirements and talk about what that means for you as employers. If you've joined us in the past, you know that I am Sophie Dietrich, the HR professional for the Compliance Center team here at Wagner, Falconer, and Judd. Our team is here to support your business as you navigate any human resource and employment law questions, and we're very happy to have you with us today. Some quick housekeeping items before we get started. Please send your questions via the chat option at the bottom of your window. We should have time for questions at the end of the presentation, so send them our way and we'll look at them then. Also, so you are aware, the webinar is being recorded to share with those who can't attend live. So, with those items covered, let me introduce you to our presenter, Janell Stanton. As many of you know by now, Janelle is a senior associate with the employment law team here at Wagner, Falconer, and Judd. She brings over 9 years of employment law and business litigation experience to the table and dedicates much of her practice to counseling business leaders such as yourselves, like we're doing today. You know, she's our favorite thought leader to have around because I say that every time. So we're excited to have her share with us today as we navigate these important changes. So again, thank you everyone for joining us. And with that, I'll hand things over to Janelle.
Awesome. Thank you so much, Sophie. And thank you, everybody, for joining us this afternoon for this webinar. Couple of just preliminary thoughts that I wanted to throw out there. First of all, these law changes are coming fast and furious. Of course, the legislative session is now over. However, I remembered very distinctly at the beginning of this legislative session a certain legislator telling us something along the lines of, we did a lot in 2023. We're going to let the snake digest the mouse. Gross. And we're not going to do that much this legislative session on employment law topics. And I would just like to say hooey, because we have a big agenda for today. There were lots of changes that were passed, nothing that was groundbreaking from a real new perspective. However, little tweaks and things that in some instances make things easier for employers and companies, and in other instances make things more difficult and more murky. And one thing I want to say is that a lot of the firms here in the Twin Cities have been writing about these changes. And even since originally publishing articles about these law changes, have come back and said, actually, it looks like the Minnesota Department of Labor and Industry is going to do it this way. So this is an area that is still very much in flux, and we are waiting for additional clarification and guidance from the Minnesota Department of Labor on a number of these issues. And so with that said, please note that what I say today is the way that we are seeing and interpreting the statutes as they've been modified or added. However, the Department of Labor may come out with FAQs before some of these pieces go into effect, because some of these don't go into effect until January of 2025 and some not till 2026. So please understand that there can be updates in the way that these things are being interpreted. So this is very much a moving target and something you need to keep an eye on. All right. So earn, sick, and safe time changes. Got a couple of little hypotheticals here for you to noodle on. First one, Josh just found out that unfortunately his grandfather died of old age. Because he's the only grandchild in the family, he's tasked with making all of the arrangements for the funeral. Josh is working for Corporation LLC, very unique company name. Love it. I'm surprised that wasn't taken, but they, Josh is put in for leave to make all these arrangements. And he was informed that he can now use his sick and safe time to arrange the funeral and deal with the financial and legal aspects of his grandfather dying. which is great because previously, as many of you are aware, Minnesota's Earned Sick and Save Time statute did not allow for employees to use time off under the ESST law for any funeral or bereavement leave reasons. So that has changed, and that was effective wait 1 second, let me go back to my notes. That's effective immediately. So now employees can use their sick and save time allotment to make funeral arrangements, attend a funeral or memorial service, or address the financial or legal aspects that arise after the death of a covered family member. And remember that family member list for Minnesota's ESST law is very long. So if an employee comes to you and they're like, oh, grandpa died, I need to use my ESST for that time, make sure you remember and recall that this is now a permissible use under ESST. This also may impact your current bereavement leave policies. It might be that your company wants to go back and take out that bereavement leave, since an employee can now use funeral leave under ESST. A decision for your company to make, and certainly something we can talk to you about, but just be aware of that. Our second little hypo here, Amy, she works as a 911 telecommunicator. She started her week during a severe weather emergency. She wants to use her sick and save time to make sure all of her windows are boarded up, her house is together before the big storm hits. This is going to be a big storm. It sounded like a hurricane. I don't know if she's in Minnesota, but essentially her boss has informed her that because of the importance of her position in a public emergency, she has to stay at work. So that's permissible if it is someone's job to respond to an emergency weather event. For example, if they're a firefighter, or in this case, a 911 telecommunicator, sick and save time cannot be used during that time. So that is something to be aware of as well. Limited application, but is a change. There was also a change made that if the employee is covered by a union and it specifically excludes weather emergencies from allowed uses, or if there's another policy as well. So again, something to keep in mind. Okay, one of the things that I know a lot of clients were particularly frustrated by was how ESST actually got paid out. So the way that it was previously worded was that ESST was required to be paid at the same hourly rate as the employee earns from employment. That's all it said. So that meant shift differentials, holiday pay, things like that, arguably had to be paid on ESST qualifying hours. However, as amended, the statute now requires that ESST be paid at the employee's base rate. So what does that mean? Base rate means for employees who are paid on an hourly basis, the same amount that the same rate that they receive per hour for work. So if they make $16 an hour, then their base rate is $16 an hour for ESST. For employees who are paid on an hourly basis that receive multiple rates. So if they perform multiple different jobs within the same company and earn different rates for that, they are to be paid at the rate the employee would have been paid for the period in time which the leave was taken. Employees who are paid on a salary basis, the same rate as if the employee had not taken leave. And then if they're paid on any basis other than hourly or salary, at a rate no less than the local, state, or federal minimum wage, whichever is greater. So that is what the base rate means now. It does also, the statute does also make clear that base rate does not include commissions, shift differentials, premium payments for overtime, premium pay for working on a Saturday, a Sunday, a holiday, things like that. And again, and this is a change in the law that was effective immediately. So hopefully this does help clarify a little bit about what rate ESST actually has to get paid at now, I think it is now a little bit more clear. Okay, Sarah, the employee. Gosh, she works at corporate LLC too. Okay, Sarah's a new employee that just started in the IT department at corporate LLC. Corporate LLC front loads 48 hours of ESST to all employees. So that means that brand new employees need to be front loaded the full allotment of the 48 hours. Sarah's only been with the company for 2 days when she's struck down with a migraine. Sarah read in the employee handbook that new employees are not given ESST until she has worked at least 2 weeks. Is Sarah entitled to sick and safe time? So under the previous law, it used to state that employees who work 80 or more hours for an employer are eligible for leave under ESST. That now is changed. So it's no longer an 80-hour threshold, but the statute has been changed to include a person who is anticipated by the employer to perform work in Minnesota for at least 80 hours in a year. Okay, so if Sarah, our new IT department employee, it was just hired on, she needs to be able to use that time because presumably she's going to work at least 80 hours this year, at least. For the only real exception is for seasonal or temporary workers where it's a really short-term project. If you don't think that they're going to meet that 80-hour threshold, that would be the exception. Just another, this was a change to the definition of employee. The definition of employee also excludes volunteer firefighters, elected officials, and certain farm employees who work less than 28 days per year. So if you are if you've got people who come in and they help with harvest in the fall, but they're there for less than 28 days, that person is excluded now from the definition of who is an employee. So that's the same. This is the same provision that changes that. All right. The increment of ESST use has also changed. Initially, the 2023 law, ESST usage was allowed in the smallest increment of time tracked by the employer's payroll system. Woof. Common increments are 1 or 7 minutes for non-exempt workers. So this made things very complicated, of course. So employees could take technically 1 minute of ESST time, and that's just probably not the intent of this particular statute. So as amended, ESST can now be used in the same increments for which employees are paid. Employers are not required to provide leave in increments smaller than 15 minutes, so no more 3 minutes of ESST time. But employers still cannot mandate that ESST be used in increments larger than 4 hours. And some of this might be like, well, who cares? Why are, all right, that doesn't seem like a very big deal. The problem that I have seen with clients over the past year since this law has been in place is companies who have PTO policies that are meant to cover vacation and sick time. In some instances, for example, for exempt employees, they require that PTO for exempt employees be used in whole day increments. That is not permissible. Employees have to be able to use their ESST in 4-hour or lower increments. And so you can't, that is no longer, that's not permissible, wasn't permissible before, but that's how I see coming up more frequently as an issue. So if you do have a PTO policy that you're intending to use to comply with giving earned sick and safe time, make sure that those increments of usage are not more than 4 hours. So those whole day increments are not permissible. They weren't permissible before either, but now you don't have to do them, allow them in such a small amount. Oh dear Lord. Okay, so we've had lots of employers, clients, doing a lot of work to make sure that their payroll systems were able to track and report available and used ESST hours on employee pay stubs. And so this is going to potentially cause some frustration, but it's meant to ease things. I just wish it had been done at the beginning of this statute, but essentially the record keeping requirements for ESST have been simplified. So now ESST, the current amount available and the hours used during that period are not required to be on a pay stub. They can be at the end of each pay period disclosed through a written or other electronic report. So that can be maintained in an HCM system. So there can just be a record of that. That's not necessarily on the pay stub. Employers can now use a reasonable method to provide this information. So it can still go on the earnings statement, or it can be provided by other electronic means, as long as there's access to that system that contains the information. So the requirements that the records be maintained for 3 years, be available for inspection upon request, all of those things are still in play. However, this simplification is meant to, I think, help. But like I said, would have been nice if they did this originally. Again, this particular section of the law is effective immediately as well. All right. Now we get to arguably the most difficult provision of these changes. And it relates to employers that provide more generous time off programs. So if your company has decided out of the goodness of your hearts that you're going to give more than either 48 or 80 hours of paid time off, PTO, and that PTO includes vacation and sick time all lumped into one. Previously, if you were to do that, if you had that more generous paid time off policy that exceeded the minimum required hours, you are not obligated to adhere to those ESST regulations, including as it related to notice, documentation, protection from retaliation, all those extra things that the ESST law provided for. Now, we previously took a very conservative approach to this, and we're advising clients that if you're going to combine PTO or put ESST into your PTO policy, make sure all of the elements of your PTO policy comply with ESST, which is a great thing, because if you worked with us to update your PTO policies, you don't really have a lot to change. But if you were advised differently or did this in a different way, now what happened, these 2024 amendments that go into effect January 1st, 2025. So here's one change where employers have some time, and thank God, because wow, what a mess. All right, so under the 2024 amendments, and I put the language here, all paid time off and other paid leave made available to an employee by an employer in excess of the minimum amount required for absences from work due to personal injury, illness, or injury must meet or exceed the minimum standards and requirements of the ESST law. Okay, so this is a change. So any paid time off or other leave that's provided beyond that, other than short-term or long-term disability, that leave then must all meet the requirements of ESST, including as it relates to documentation, notice, anti-retaliation, replacement workers, because remember, under paid sick and safe time, you cannot require that an employee calling in sick find their own replacement. That's a no-no, and an area where I have seen employers get sued. So essentially, this is a pretty big change here. And I'll touch on something here in a moment. That additional PTO, like I said, has to meet all of those same requirements except for the accrual rates. Originally, it seemed like the amendment was only going to require protection of PTO used for personal illness or injury. And why would we think that, pray tell? Well, because the legislature said for absences from work due to personal illness or injury. So I'll give you a quick example here. Let's say that you are a company that provided your employees you give your employees 120 hours of PTO. You're very generous, and that PTO can be used for any ESST covered reason: vacation, personal matters, all the sick time, all the safety time relating to domestic violence, stalking, all of that. If you do all of that, great, love it. Then as long as it all aligns with the ESST requirements, what we thought was that only at past that 48 or 80 hours of ESST, you only had to apply those ESST heightened protocol to absences due to the employee's own illness or injury. So when we were reading this, we thought, okay, if after they've used their full allotment of PTO for other qualifying ESST reasons, the family's member's illness, domestic abuse, funeral leave now, then the only absences that were still going to be protected by those heightened ESST standards were those relating to the employee's own personal illness or injury. But the Department of Labor has now said, actually, what we're going to do is we're going to take a very broad interpretation of this particular provision, and we're going to state that PTO can be used for any reason covered under ESST, not just for personal illness or injury. And all of that time for any use has to still be subject to the protections of the Earned Sick and Safe Time statute. All right. Clear as mud. This is without a doubt, I think, the most complicated provision here. Now, what can be done from an employer's standpoint? There's a couple of things. One option, so if you can track PTO into pre-2024 and post-2024 accruals, if that is feasible, you can still impose your pre-2024 notice and documentation requirements on older PTO. If you cannot 100% with confidence separate that out, what you want to do, if you want to still be able to maintain some control over PTO that's used exclusively for vacation, you're going to need to carve out PTO for vacation reasons into one bucket and PTO for sick and safe time reasons into a different bucket. And so PTO that's used solely for vacation, you can say you got to give 1 month of notice, or you have to provide some kind of documentation, or there's the anti-retaliation provisions don't apply. So abuse of PTO for vacation is subject to discipline, things like that, or failure to, get the appropriate notice. And then you have to say for PTO for earned sick and safe time reasons, you've got to 7 days notice, and you can't get documentation until after 3 days of successive ESST use, things like that. So you can carve it out that way. And we have drafted policies like that for many of our clients. So we have done this. So that is one approach if your company wants to continue using PTO. And again, I use the term PTO as a policy that combines vacation, personal days, sick time, all of it into one lump or one bucket. The other option is you might need to reconsider your approach here. And you might want to separate sick leave from vacation time. Sick leave subject to ESST, all of those onerous rules and protections, and then do vacation time separately. Because currently in Minnesota, there aren't rules for the most part relating to vacation time. So you could give vacation only to full-time employees or only to exempt employees. You can require that an employee work for a year for your company before they become eligible for vacation time. I'm not saying these are genius plans. I'm just saying you could hypothetically do these things. Whereas when you lump vacation and sick time together, now what you can do with vacation is much more limited because you've got to apply all of those ESST rules to your PTO when it's lumped in. So for some companies, it may make very good sense to stop using a PTO bank and start separating sick leave from vacation time. All right. Hopefully you guys all bared with me through that. I know that's a tough one. But when I kind of said at the beginning, some law firms have walked back what they originally said. This is what we're talking about. And it's because the Department of Labor came out and said, no, it's not just for absences for, work due to the employee's own illness or injury. It's all reasons. So this is leading us to do sort of an about face and figure out what in the world Dolly wants us to be doing here. All right, paid family and medical leave. So moving on to our next topics, because we still have quite a lot to get through here. Please remember that this is not effective till January 1st of 2026. And if you will recall, we did some presentations on this last year talking about paid family and medical leave and what's to come. But essentially, it provides time off for family and medical leave, bonding, adoption, and pregnancy, serious health conditions. And I think that, I'll just leave that for now. We can talk more about this when we get closer. But essentially it gives protected and paid time off for a number of qualifying reasons. So some of the changes, and again, these aren't effective until 2026. But one of the changes is deed. And so if you recall, this is not a program that is implemented by the company. The Department of Employment and Economic Development, DEED, is creating a department who is going to handle and pay these claims. So employees don't apply for this leave from their employer. They apply for leave benefits under PFMLA from DEED, very much like how unemployment works. If you lay off an employee, you do not receive their application for unemployment. DEED does. So DEED is going to be the one collecting these requests. They are the ones who are going to be paying all of this. So this is not something operated by the employer. One of the changes is now DEED has to notify employers within 5 business days of the date an employee makes a claim for benefits. So before, one of the things was, well, if we're not doing this process, how do we know if, Jane has gone out and applied for PFMLA because she's going to be having a baby? So now there is this notification process where DEED will notify employers within 5 business days of when an employee makes this claim. Couple of other changes. So originally, employees that were receiving severance pay were ineligible for PFMLA. That language has been struck out. And again, I think this is very much indicative of the fact that between now and January 1st of 2026, we could see a whole lot of other changes made to this law. We have election cycles coming up that, depending on the outcome of those elections, there could be further modifications made to PFMLA, could be fully struck down. We don't know. So we put this information out here so that you're aware of it and you know, but like I said, we got a moving target happening here. So just the fact that this one little piece was struck, there could be significant additional changes to this law. Employees can use PFMLA on an intermittent basis, much like they can with the federal FMLA law, as long as the policy allows for increments no smaller than 1 calendar day. Employees may not be paid more than their usual pay during the time they're taking PFMLA. So if while they're on paid family and medical leave, they receive some other kind of extra pay or supplemental benefits that bring, I don't know why I put her here, but that is a typo, so sorry, that bring the employee above their usual pay, that may have to then be paid back by the employee. So they are not to be paid more than their usual pay. So this is not meant to be a big windfall to employees who might be getting paid leave and short-term disability and other types of payments. However, employees can receive both disability insurance payments and PFMLA. However, that disability insurance benefit may be reduced by the amount of PFMLA benefits that are paid according to the terms of that disability insurance policy. So again, this is an area where we have some time. It's not effective till January 1st, 2026. So maybe if you're, a company that self-insures a disability insurance policy, or you may need to get with your insurance carrier and look at how do we update the terms of these policies to accommodate these changes that are made. Okay, true or false? I don't have any polls to run, so just, honor system here. True or false? An employer may substitute a private plan that gives employees paid leave under the PFMLA laws and is not required to provide equal benefits. So as long as they do a private plan, they're not required to provide equal benefits. Is that true or false? And if you're saying, Janelle, that's absolutely false, you are correct. Winner. So an employer is allowed to provide their employees a private plan for PFMLA instead of using the state program. But in order to do so, the benefits must be equal to the PFMLA requirements or better. So you can always do more. You can't do less. Private plans have to meet the eligibility weekly amounts, the total weeks provided. They also have to go through a process to get that plan approved by the commissioner at least 60 days before the plan takes effect. So that approval still has to happen. All right. Ooh, I have another true and false here. All right. True or false? Okay. Amy is pregnant and unfortunately suffers from hyperemesis gravidarum. And if any of you are not familiar with what that is, it's absolutely terrible condition that makes a pregnant person extremely sick, nauseous, vomiting, things like that. So Amy's very, very sick and she's requesting leave as an accommodation under Minnesota's pregnancy accommodation law. True or false, her employer can, for the duration of her leave, cancel Amy's group health insurance because she will no longer be considered an active employee. So is that true or false that the employer can do this? And again, if you guess false, you are correct. Minnesota's pregnancy accommodation law and pregnancy and parenting parental leave law has been updated to provide that during any leave that's provided as an accommodation for a pregnant employee's disability, the employer has to maintain coverage under any group insurance policy, group subscriber contract, or health care plan for both the employee and any dependents. But the employee must continue to pay any employee share of the benefits cost. So even if she is suffering from this condition at the very beginning of her pregnancy and she's got a long ways to go, and she's probably not considered an active employee under the terms of your health insurance policy, that group health insurance still needs to be maintained provided Amy is paying her share of that benefits cost. This provision, it goes into effect on August 1st of 2024. Okay, here's a fun change. Very interesting. Minnesota, as many of you know, has one of the most difficult to comply with drug and alcohol and cannabis testing laws in the nation, probably surpassed only by the state of Iowa. And it's the Drug and Alcohol Testing in the Workplace Act, or otherwise lovingly known as DATWA. DATWA places puts very stringent requirements on employers who are wanting to do drug, cannabis, and alcohol testing of their job applicants and employees. And previously, what was required was all drug, cannabis, and alcohol testing had to be performed in a licensed laboratory. So some states, I don't know why, allow employers to do urine testing in their own workplace, and yuck. But they do allow it. Minnesota was not one that allowed that. However, they're effective August 1st. Oral fluid testing is an alternative method that employers can use to test employees or job applicants for the presence of illegal drugs, cannabis, or alcohol. Now, the testing still has to be performed. So the oral fluid testing, saliva testing, can only still be performed when that type of testing is legally permitted. So, reasonable suspicion, post-accident, post-treatment program testing, that sort of thing. So as long as there is a permissible testing purpose under DATWA, employers can request that an employer applicant undergo oral fluid testing. The applicant or employee has to be informed of the test result immediately. If the result is either positive, inconclusive, or invalid, the employee or applicant can request a laboratory test within 48 hours at no cost. If that lab test is positive, then any confirmatory retesting can be paid by the employer applicant, but at their own expense. So this is an interesting development because some companies have, second or third shifts where sending them to a lab to do testing is very difficult because nothing is open, or maybe you're operating in a place that's really remote and difficult to get to a testing facility. So I think this oral fluid testing will open up some avenues for employers to do different, or to obtain testing, especially reasonable suspicion testing, when a lab is not maybe necessarily open during a third shift, 1:00 in the morning. Then if that test result is positive, then there can be this laboratory test within 48 hours, presumably when a state licensed laboratory is open to do this drug testing. So very interesting. If you are at all thinking about implementing oral fluid testing, please do work with counsel to make sure that you're Drug and alcohol testing policy is updated because you do have to give notice of this. There's some other parameters around oral fluid testing that you need to just be aware of. So if you're thinking, wow, this is great, I don't have to do a urine test in my office, but I can now do this oral fluid testing of employees. Great. Yep. Let us know or work with your counsel. I think this could be very, very helpful. All right, it's getting grim out here for independent contractor status, guys. This is Minnesota has passed a new law. This went into effect on July 1st, so already in effect. Minnesota Statute 181.772 was modified to add new awful, terrible penalties for employers that misclassify employees as independent contractors. So if you're hearing me and you think, we have independent contractors, this is a very, very good time to sit down with potentially the help of counsel to determine, are all of our independent contractors properly classified? Because if you don't, owners, partners, principals, officers, basically the powers that be at your company who knowingly misclassify employees can be personally liable, sued individually for misclassification issues. This, again, is very uncommon. Most times, employees are only able to sue the company in general, almost never an individual in particular. But here, any owner, person who runs a company that knowingly misclassifies somebody can be personally on the hook. And to make matters worse, personally on the hook for compensatory damages. So employees, per the changes to this statute, can now be awarded compensatory damages, including overtime, vacation pay, sick and safe time pay, health insurance, any other benefit that the employee missed out on due to the misclassification. And will this make sense, right? Because if we're saying somebody's an independent contractor, they don't get overtime. They're not getting vacation pay. They're not getting ESST. They're not made eligible for health insurance. So the damages now for somebody who's improperly classified is ballooning. There's a lot more things that you would have to pay potentially if it's found that you've misclassified an employee as an independent contractor. And there are new penalties of up to $10,000 for each misclassified person and each violation, and a penalty of up to $1,000 for each person who fails to cooperate with any investigation into the violation of these classification laws. So here again, and this is a gavel, but I kind of liked the thought of we're bringing the hammer down. Independent contractor status is very much seen negatively, and many of the state and federal agencies have vowed to start cracking down more and more on company use of independent contractors. If you are in the building, construction, or improvement services industry, so your company does new builds or remodels or things like that, clutch your pearls, because there's a new independent contractor test for any individual that provides or performs building construction or improvement services. So they cannot be classified as an independent contractor unless they meet all of the requirements of subdivision 4, paragraph A, which I'm now realizing I didn't put the statutory site in there. So if you're in this camp and you are like, I need this information, Janelle, please reach out in the chat. I will get you the statutory site. I'm sorry I didn't include it here. I did mean to do that. But if the individual providing these services does not meet all of the requirements of subdivision 4, and there's like I don't know, at least 15 or 16 of them. I included some, and then you'll see my little et cetera down there. I didn't have enough room, but they have to meet all elements of subdivision 4 paragraph A. So they have to have their own independent, established and maintained company from the company for whom the services were provided. So like, we have general contractor here and then subcontractor here. They have to have that independent contractor to be properly classified. They've got to have their own business. It can't just be their individual. It's got to be a business that's established and maintained separately. The independent contractor has to own, rent, or lease their own equipment, tools, vehicles. They have to provide the same services for multiple persons or to the general public. They've got to have a federal employer identification number if required, or have a Minnesota tax identification number. They have to be in good standing with Section 5.26. Don't ask me what that is. They have to have an unemployment insurance account. They have to have obtained work comp insurance coverage if required. They have to operate under a written contract to provide the services. There's a litany of things here that need to be met in order for somebody to be properly classified as an independent contractor in the building, construction, and improvement services sector. So again, if you are looking at this and you're saying, yep, that's me, oh my gosh, don't just reach out to us. We can provide you some assistance and some help in getting you on the right side of this particular test. That is effective July 1st, as I said. Okay, we got some revised definitions in the Minnesota Human Rights Act. And so now do you see what I meant? They didn't give us a year off. This is still complicated. So maybe 2025 is our year for a little employment law vacation, but I somehow doubt it. We've got some new definitions that make a big difference, I think. As far as discriminate, so the term discriminate used to be defined as to segregate or separate, and for purposes of discrimination based on sex, it includes sexual harassment. Now, harassment is not just limited to sexual harassment. So it expands the scope of discriminate to include any harassment made due to any other protected class status. So race, national origin, disability, things like that, which dovetails nicely into my next updated definition here, the definition of disability. Formerly, the definition of disability was any person who has a physical, sensory, or mental impairment which materially limits one or more major life activities, or if that any person who has a record of such an impairment or is regarded as having such an impairment. Now, just add a little plus sign, plus now a person who has an impairment that is episodic or in remission and would materially limit a major life activity when active. So I've not been shy about this. I'm a breast cancer survivor. So I'm in remission. And if I had, I'm in remission from that. But if I were to, hopefully never have a recurrence of breast cancer, obviously that would materially limit a major life activity when active. That is potentially a disability still under the Minnesota Human Rights Act. So this is a pretty substantial expansion of the definition of disability. So just keep this in mind, that the Minnesota Human Rights Act applies to companies that have one or more employees, so all of us. And this is a broadening of that. So if an employee asks for an accommodation for a disability, but you're saying, wait a minute, you don't have cancer anymore. Well, this might now qualify. They may now still qualify for accommodations under the MHRA. Familial status, the definition of that was expanded upon as well. Familial status is now includes residing with and caring for one or more individuals who lack the ability to meet essential requirements for physical health, safety, or self-care because that individual or individuals are unable to receive and evaluate information or make or communicate decisions. So this is somebody who is incapacitated in a way that they cannot care for themselves. And so familial status does include those individuals who are residing with somebody like that. Got just a couple more here. All right. So effective January 1st, 2025, Minnesota is jumping on the bandwagon and joining a number of different states that are passing these salary or pay transparency related laws. So already, employers in Minnesota were not permitted to request information about previous salaries. Now, add on to that Minnesota law effective January 1st, 2025, and I include the date here again so you have time to digest and deal with this. Minnesota law is going to require that employers disclose salary ranges in all job postings. So employers are required to disclose in every job posting the starting salary range and a general description of all benefits and other compensation, health insurance, retirement benefits that are offered to the hired applicant. And so the salary range, that means the minimum and maximum annual salary or hourly range of compensation. It's not just for exempt employees, the minimum range of compensation based on the employer's good faith estimate. So it can be open-ended. You could say, 90 plus, depending on qualifications or something like that. But if you don't want to post a range, then you have to list a fixed pay rate. So this is a big deal because now if you're going to be going out and posting for a job at your place and you've got employees who are already occupying that role who are making less, this now becomes very visible. And I think there's two issues here that are going to come up quite frequently. One is you're going to have your existing employees say, wait a minute, I've worked here for 6, 7, 8 years. I do a great job. And you're going to hire somebody off the street who has no experience and they're going to make more than me? No way. That's number one. The second issue, which is I think almost worse, to be sure, is that there can now be pay equity issues brought to light. So if you have either purposefully or what I find to be most often unintentionally, if you have pay equity issues in your workplace, these are now potentially going to be brought to light because if you've been historically underpaying women or other folks of a different race or a different national origin less, these pay inequities come to light. So we've got time. That's the great news. The not so great news is it does have a tendency to go by very quickly. Before you have to start posting these salary ranges, I highly recommend that you do some deep internal thinking about what the consequences may be to your company once you start having to post these salary ranges. So do you have folks that are going to be below your published or posted salary range? And if so, what are you going to do about that? And it's a great time to do a pay equity audit as well. So pay equity audit, I highly recommend that they be conducted under attorney-client privilege, but it's not a requirement. Essentially, you look at all of your employees, you look at who's in what jobs, what are the pay differences? Are there any pay differences based on impermissible factors like gender or race? How do we remedy those and get people to be within the proper salary ranges? So that audit, it's time intensive, labor intensive, process, but it is something that we highly recommend so that once you start posting these salary ranges, you have very little heartburn, at least, probably never no heartburn, but very little heartburn about what those ranges are going to advertise externally. All right. Oh, we have one more true and false. Okay. Corporation LLC, again, our ever cleverly named company, is considered a large employer and therefore by law must pay their employees at a higher minimum wage rate than small company who is considered a small employer. Is that true or false? That's false. So that hasn't been false. This is a change. Previously, small employers and large employers had different minimum wages that they had to comply with. So this new law it standardizes the minimum wage in Minnesota that removes the carve out for a lower minimum wage for small employers. Employers of foreign workers on J visas and those in the hospitality industry and folks under the age of 18. So some fairly significant changes that are coming into, those go into effect January 1st, 2025. So if you are somebody who is like small company and were considered a small employer, you should note that that change has been made. Also, the annual minimum wage increase is the way that that calculation is being done is also changing. That changes August 1st. Essentially, what Minnesota is going to be doing is taking the lesser of 5% or the percentage calculated by the commissioner, increasing how much the minimum wage can rise each year because of inflation. So it's going to 5%. Previously, it was 2.5%. That goes into effect on August 1st of 2024. So those minimum wage increases may start taking a little bit more substantial jumps over time here. So, all right, I know that's a lot of information, and I understand that, again, we were just wrapping our heads around and feeling comfortable with earn sick and safe time and some of the things, as they were. But these changes, they're here for now. Don't bank on a new administration. Don't bank on, I don't know, a legislative change of heart. So make sure you're thinking about how you're going to comply with these things. We only have a couple of minutes left. I'm sorry, I knew I'd chew up a lot of this time, but Sophie, do we have any questions that came in?
Hi, Janelle. Thanks. Yeah, we do. One came in. So, if ESST laws have changed for bereavement related leaves and the company requires proof of death or an obituary in order to be paid, does that mean the proof policy is no longer valid and we cannot ask for that proof any longer?
Correct.
Okay.
If you're
Awesome.
going to be, so here, one thing I want to say though is you can have, so if you note that funeral leave addition to ESST is just that. It's for funeral leave, to make funeral arrangements, attend the funeral, and legal matters, essentially. It does not provide ESST for sadness. And employees need sometimes bereavement for sadness. So if you want to maintain over and above what ESST requires and have a bereavement leave for sad time, you can apply different rules to that. It's just if it's for funeral leave, if you're going to strike out your bereavement policy and just go with ESST, you've got to comply with the documentation requirements of that law.
Thank you. And then another one came in related to the new increments for ESST time use, and they were curious if that was only applicable to front-loaded ESST employees.
All. Yep, those increments of use are applicable regardless of whether you use the accrual method or the front-loading method.
Okay, thank you. And then we have two more. Do we have time for that, you think?
Yeah.
Okay, great. So then also related to ESST with more generous time off programs, um, someone asked, ESST says all other paid time off must meet ESST requirements. Would that apply to paid personal days awarded to employees from the company?
It would, I would, I have to throw back a question, and I'm sorry to do the lawyerly, it depends, but it does depend. I would need to know more information about the what personal leave is used for. So if personal leave can be used for some of the same reasons as ESST, potentially yes, but I can't really answer that. So whoever has asked that stumper of a question, thank you, and please reach out to us so we can walk you through how to handle that situation.
Great, thank you. And then the last one we have is about the paid family and medical leave. They're wondering if employers can still have their own LOA request process separate from the deed process so that they would know the employee is out.
Yes, you can still maintain your own process. Um, you're going to find out from deed within 5 days of the request, but yes, you can still maintain, as far as we know right now, we can still maintain your own um, leave request policies. Again, they would have to be compliant with all other applicable laws. So, depending on the reason for the leave, if it's FMLA qualifying, remember that there are time frames within which an employee can, be required to provide leave. So, just make sure you're not, by instituting that type of LOA policy, unwittingly or accidentally violating any of the FMLA edicts.
Okay, great. Thank you. That is all of the questions we have.
All right. Well, thank you so much, everybody, for attending. If you have any questions about our services or you want to learn more, I've got Chris's information here. Light him up with questions, and he'll pass them along to us as well. So thank you, everybody, and have a wonderful afternoon.